Hello everyone, welcome back, happy Monday. In this video I'm going to talk to you about the difference between the Baker Act and the Guardianship statute. Now in the past I have told you, I think I made a number of videos about this, the fact that the Baker Act statute is not a treatment statute, meaning it's not designed to treat anybody. It is a statute that allows the state of Florida to take temporary custody of somebody when, as a result of some type of mental illness, there's an emergency situation. And when I say emergency, I mean to the point where you would be picking up the phone and calling 911. That's an emergency where somebody is an immediate threat to themselves or potentially others. That's what the Baker Act's for. And the idea is that you get the law enforcement, typically who are called to the scene, will come. They will initiate a Baker Act. And the person gets taken to the receiving facility, and the idea being that you should be assessed, stabilized, and released. Okay, that's it. Now I've put out probably hundreds of hours of videos at this point about the abuse of the Baker Act. So I'm not gonna go into all those details again, but it is a statute that allows, perhaps that's not even the right word, authorizes the state to take custody of you. And once that happens, your rights as the detainee to make decisions for yourself have been suspended. They're gone. They no longer exist. And the rights of anybody else in your family to make decisions for you, whether you're an adult or a child, they're suspended too. They are gone. They are over, terminated. And so I get a lot of calls, and I had one today from a very nice individual who was in another part of the country, who has a brother down here who has serious mental health issues, and he spoke to a clinician. She said, oh, they have this amazing statute in Florida called the Baker Act. Why don't you call a lawyer down there and ask about Baker Act and your brother? And I said, before we get into all of the facts here, unless you're telling me that this is a situation where you would call 911, you don't want to Baker Act your brother. So let's take a few minutes to discuss that. And so what we talked about was guardianship. Now the guardianship statute is a statute that allows the guardian, which could be a parent, it could be a significant other, a spouse, it allows that individual to have the authority given to them by a court so that they can make decisions for their loved one. Now, their loved one's rights, the 12 of them that I've outlined in previous video, you know, when they become a ward of the in a guardianship case, not a ward in a Baker Act case, the 12 rights that can be terminated or suspended, those rights then get handed over to the guardian, the person who now has the authority to make decisions. So in the Baker Act, it's the state who is basically the guardian, and in a proper guardianship filing, which is a private action, say between parents and child, or adult child, I should say, it's the parent that gets the authority, not the state of Florida, which means the person who knows you best potentially is the one who gets to make the decisions for you. Now, that doesn't mean to say that if the guardian puts you into treatment or puts their adult child into treatment, that they couldn't then be Baker Acted, because the idea is that if they're in treatment and they need a higher level of care, then yes, the state can step in. But there's a guardianship there, and there's a guardian there who's been authorized by a judge to make decisions for the ward. And so if the state doesn't want to step out of the way, we can then go into court and say, hey, judge, there's a guardian that's been appointed by another court, and we need to move the state out of the way because the person's now been assessed and stabilized. They need to be released, and the authority that was given to the guardian needs to be respected. Whereas if there's no guardian in place and there's a Baker Act, well, good luck, because now you have the tough fight to get your loved one out of this facility. And you know from other videos that if you have insurance and you even come close to meeting criteria, you know the facility is going to fight like hell to keep you, because this is how they make money. The unscrupulous ones, that is. They're not all unscrupulous, but many of them are. And these are the ones that we tend to do battle with, day after day, week after week, month after month, year after year. You get the picture. So I wanted to outline the difference between the two, because in lots of cases I'm getting calls, and more of them just recently, police telling people to Baker Act their loved one, clinicians telling people to Baker Act the loved one. And look, I get it. I think that the police, the clinicians, they all come from a place of love. They mean well. But please, please, please stop telling people to Baker Act their loved ones. It's not the right thing to do. If it's that bad, pick up the phone and call 911. But if you are having to go to court to file a Baker Act petition, then you can go to court and file a guardianship petition too. And we can do those on an emergency basis too. And then you get the right authority to make the right decisions, as opposed to you hand your loved one over to the state and then you're like, holy smokes, what just happened here? I made a big mistake. Yeah, you made a big mistake, but you did it not knowing that you were doing it, not meaning to harm your loved one, but just unfortunately being given the wrong advice. So that's the big difference. I wanted to share that with you. And if you need any more information about, what should you do to get your loved one help, then call us. I'm here to help you. With that said, thank you. I will see you tomorrow in the next video. Bye-bye.